America's founders are calling. It's your opportunity to respond. This is the Liberty Brief Podcast with your host, Robert Melso, featuring Dr. Thomas Giordano. Welcome to episode 7 of the Liberty Brief Podcast. Once again, we're here with Dr. Tom Giordano, author of the book Unalienable: What It Really Means and Why It Matters. Now, we've had a few episodes, and in the last episode, we examined the uniqueness of our Constitution and its innovative intentions. We looked at how its structure was derived from various Greco-Roman concepts of governance and how the founding generation merged the philosophies of an ideal mixed polity with the notions of federalism borrowed from the Iroquois Confederacy of the Six Nations. Now, I don't mind admitting that I was amazed at the influence of the leader of the Confederacy, Canisitego, on Ben Franklin. It was our hope that we could explain in a brief way what had been given to us by our founders, because we can only recognize what changes have occurred if we know what we had to begin with. Now, in this episode, we'd like to start talking about solutions, finally. We have to realize that we are at war with forces that are seeking to actively destroy our uniqueness. So, how will diagnosing the abuse of our U.S. Constitution offer us a remedy? In other words, how do we know what to treat? So, where do we begin? Let's start with a welcome. Hi, Dr. Tom.
Hi, Rob. I hope everything's okay with you.
Va bene, as we say in Italy.
Va tutto bene con te? Sono contento che tutto sta bene con te. Vabbè.
Sono terrific. How do you say terrific in Italian? I forget.
Terrifico.
Terrifico.
But that's not what they would use. You would say, mi sento benissimo, o sto benissimo.
Mi sento bellissimo.
Ecco, bravo.
How about if I say as well as can be, Dr. Tom? So let's jump right in here.
Okay. Okay.
If we were to take the survival of our federal government seriously, and you and I both agree that there are things that need to change and fairly quickly, where would we begin?
Well, Rob, firstly, we'd have to realize what our objectives are and create a mission statement. Then we'd have to identify specific dysfunctions and order them according to a prioritized list by the danger they pose to our government, to our natural and to our civil and political rights. From there, we'd have to determine the legal and constitutionally sanctioned course to correct them. In any war, there are two things that must be formulated beforehand. The first is strategy, and the second is tactics. Strategy is the political objective for the fight. In our case, the strategic task would be to return to our first principles, and this would be guided by the text of the original Constitution, unamended beyond the Bill of Rights. In other words, the first category of what to address would be that of original intent.
So you're implying that knowing what these first principles are would be a key factor in creating the strategy. So what kind of measures do we use to determine if our first principles have been or are being degraded? I mean, how do we arrive at original intent?
Well, just hold off a bit, Rob. I think you're jumping ahead a little bit here. Let's stick to the framework of what we want to achieve. We're laying out our mission. It is our mission that will tell us what our infrastructure should be to accomplish our aims. It will also determine our priorities, but we'll get to materials and methods in due time. This would fall under tactics.
Okay, tactics being from the Art of War and many other books, the judicial use of forces and resources in the field.
Right.
And how to deploy them.
Right, exactly. Exactly. That's exactly what it means.
Okay, I get where you're going. And I've written up a few business plans in my own time. So we want to state our mission in a very simple and straightforward way. That's always the best.
Yes, it is. Yes.
You've already mentioned that the strategic task would be the return of the first principles found in the text of the original Constitution, unamended beyond the Bill of Rights. That sounds like a pretty good mission statement to me.
Well, as good as any, I guess. Sure.
But do you really think it would be wise to just abolish every amendment,
Oh
especially
no,
after the 10th?
no, not at all. That's not what my intent was. We don't necessarily want to abolish every amendment after the 10th. That would be extremely foolish and probably not very effective. There are positive amendments that are grounded in moral and ethical bases, which don't violate the spirit of the Constitution. That should stand. That should remain. But we're not there yet. We're not at that point yet.
Okay, I've
Um,
been accused of being impulsive before, so I'm just trying to see where you're going.
okay, it's no problem. No problem. You see, I have the mind of a clinician. I've been in healthcare for 33 years, so I have the mind of a clinician. So I'm more apt to follow a simple, reasoned approach. You see, Rob, any good doctor will tell you that 99% of any treatment is knowing the diagnosis. Okay, we arrive at a diagnosis by recording the subjective complaints or the symptoms. That's what they call symptoms. It's something you feel, all right, and combine them with objective observations or signs. It's something that I see and that another colleague would see. So there's inter-examiner accordance with what we're seeing. Okay, something that this is an objective observation. The signs and symptoms will lead us to a clinical picture. Okay, if the picture is obvious, we have a diagnosis and can start treatment. If it's not so obvious, we need further study to rule out presumed diagnoses to arrive at the actual one. So let's get some things clear in our minds. Do you remember in the last episode, we talked about the classical Greek observations on the natural cycles of polity, how Plato, Aristotle, and Polybius also talked about the ideal mixed polity being a combination of the desirable aspects of each form of the governments that they were aware of.
Yes, but don't ask me to recite all that.
No, okay, I won't. But what we need to realize is that the actual structure of our federal government is designed to preserve the self-governance of each state and the natural rights of the people. It was to deal primarily only with foreign policy, leaving domestic policy to the states and to the people. This was the desirability that Plato spoke of. Federalism was their answer. It was not conceived to be a centralized, all-powerful government, just the opposite. It was not designed to be a direct vote democracy at all levels. This is precisely what they wanted to avoid. Now, let's look at each of the co-equal branches of the government and make some analogies with what the Greeks described. If we look at the executive branch, this would be like a benevolent kingship, okay? In the legislative branch, the Senate would be similar to the aristocracy, that is in the Greek sense of the word. The House of Representatives would be similar to a direct vote democracy. The judicial branch would be like a timocracy. You see where I'm going with this?
Yeah, I think I see where you're going. The natural cycles of polity that they spoke of were in terms of degeneration from positive to negative forms of government.
That's it. That's it. If you remember Polybius, he described them going from degeneration to degeneration to degeneration. That is the key to understanding how we set our priorities on what to address first. The benevolent kingship of the executive branch is degenerating into a tyranny. The senatorial aristocracy has already degenerated into an oligarchy. The House of Representatives seems more like mob rule than a judicious direct vote democracy. And the judicial democracy is infected with leftist political ideologues who act in accordance with nonsensical ideas. Some of them claim we have a living constitution that should be broadly interpreted to mean anything they want it to mean, regardless of what the actual narrow legislative intent was. Here, more than anything else, we're looking at structure. Now, in the biomedical sciences, there is a maxim that applies to our situation. Structure governs function. By the way, this was given to us by the father of osteopathic medicine, Dr. Andrew Taylor Still. We have him to thank for that insight into healthcare. So basically, there we are. Structure governs function. And that's the first thing we should look at.
All right, I'd like to take a little sidebar here and just jump off this for just a minute. There are some very intelligent and learned folks that have become Supreme Court justices,
Right.
much beloved by some people on the left side of the aisle, Ruth Bader Ginsburg, who has
Right.
followed the living Constitution claim.
Mm-hmm.
What would you say to people who think that the living Constitution is justly the way we should be interpreting the rule of law today?
I'd say it's malarkey. It's a load of it's a load of horse crap. The document is
Malarkey is a word I haven't heard since 1968.
well, I what can I tell you? The Constitution, for all intents and purposes, is a commercial charter. It's a contract. Okay, if it were a living Constitution, as they say, subject to broad interpretation, first of all, we would not have an amendment process. There would be no need for an amendment process. All right, to change anything in the Constitution. You can't willy-nilly change clauses unilaterally in a contract, in a normal contract. Why would you be able to do it in a Constitution that is let's say, the mission statement and the operations procedure of a government? It makes no sense whatsoever. Let's say, for example, we have a contract and I have an obligation to sell you 20 tons of oranges. Okay? Let's say I unilaterally change it to apples without your consent. Let's say I change the definition of the word orange to mean any fruit I want. What do you think would happen in that if we were to go follow through on those transactions? You would sue me. You'd say, I asked for oranges. You're giving me kumquats.
Well, let me just take that example and counter that. Let's say 100 years have gone by and oranges are now deemed to be harmful by various scientific agencies. And we have this contract, and now we have to take a look at it and say, wait a minute.
Okay.
The original intent was to deliver a healthful food. Now this food isn't so healthful anymore.
All right. What would you do in that situation?
We'd have to amend the contract.
You would get the parties together and amend the contract and strike out oranges or any other harmful fruit and replace it with a good fruit. There's a process.
Oh, you mean like avocados?
Yeah, sure. Like avocados, like I don't know, grapes. I have no idea, whatever you want to replace it with. But the fact of the matter is that there is an amendment process. You don't just unilaterally change the contract.
But I think these people are oftentimes in a hurry and they say, we can't wait for amendments.
I don't care. I don't care about their hurry. The process is included in the Constitution. We have an amendment process. However much time it takes, it takes. It's
right.
Really that simple.
Well, I'm going to bring Sotomayor into this next conversation.
You could bring her in, but I wouldn't agree with her either.
Yeah, but we'll ask her when she comes on.
Yeah, okay.
So
good, because we can have the entire discussion in Spanish. This way, nobody will understand it. Except
so, structure governs function. Let's get back to that.
Yes.
I think you're implying that if the structure is in some way damaged, things will lose their function. And then that's basically what you're saying.
Yes. Well, it may not lose its function completely initially, but it will lead to a dysfunction that'll progress to degeneration with time if not corrected. We can view any alteration in the original structures of government as the onset of a degenerative process, which then sets up an environment for pathology. In medicine, they would call this etiopathogenesis. Etiopathogenesis means the beginnings of the environment for the creation of a pathological process.
Okay. And what comes to mind when you say that is that we are all agreed as American citizens to live up to the Constitution. We pledge our allegiance to it.
Yes, we do.
And when we set up this extra constitutional process without our consent, a lot of us get upset. And I would say that a perfect example would be Roe v. Wade, where many people were rightly upset that it was stated that abortion was a right. No such thing had appeared in the Constitution, and that laid the groundwork for its eventual demise, recent demise.
Right. Well, they didn't claim it was a right. They claimed it was a constitutional right. Okay. There's a difference. They're talking about here a false construction because the Constitution never talks about abortion. It never talks about it. If we go back to the original intent of our Constitution, the government was never to have even made a comment on abortion. First of all, the government does not concede rights. It only has privileges that we granted to it from our rights. Okay. Now, if I don't have a right to sit there and dictate whether you can or cannot have an abortion, I can't concede this as a privilege to the government that's acting in my name. Number one. Number two, the government does not concede rights. It's not God. It doesn't have the ability to say you have a natural right to do something. It can't even comment on it. It can't even comment on natural law, the Supreme Court. So it was a false construction. It was a bad opinion from the beginning. And look at the consequences of that bad opinion, no matter how you look at it. You're talking upwards of 63 million dead fetuses. Now, I don't, like I said, I am not completely against abortion, okay, to save the life of the mother. There are situations, especially when her life is being threatened, there are reasons that make that a medical necessity, okay, to save the life of the mother, period. Then you have other things that they get involved with, what about rape? What about incest? All right, these are all things that should be handled at the state level, not the federal government. It's not the federal government's business, period. So it was a false construction. Now, when they struck it down, it had no effect on the individual states where it is permitted. You have to also understand that when they passed this opinion, let's say by the Supreme Court, first of all, the Supreme Court has no ability to pass a law. It was an opinion. Just an opinion. It was no more valid than the opinion stating that slavery was permissible. If you could strike that down, why can't you strike this down? Number one. Number two, you said about talking about rights. The government does not grant them. When people say, "Oh, I have a constitutional right to free speech," no, you don't. You have a right to free speech that the Constitution cannot impede. It has no position in granting it or not granting it. People don't understand that when we're talking about negative rights that are enshrined in the first 10 amendments, they are negative because the government has no ability to intercede in them. What does "shall write no law" mean to people? It means that these rights preceded the drafting of the Constitution, and the people held them to themselves or to their states. So if a person wants to live in a state where abortions are free and open and all this, well, they're never free. Somebody always has to pay for it. If they want to live in a state where it's not criminalized, go live there. It's that simple. Or get like-minded people together, pass an amendment in your own state's constitution to permit it. But don't sit there and order it from on high, giving an authority to the federal government that no such authority exists, in the Constitution. It's a false construction.
Okay. Well, I think I took you far enough off track.
Right? Yeah, well, it irritates me because people don't understand what they're protesting. And it's interesting that these people that are protesting in states where abortion is permissible. So they're sitting in California, running around in the streets, burning them, crap, when it's totally permissive. It doesn't change anything at the state of California or the Republic of California.
Okay, that gets more into the degenerative process of some of the electorate.
Exactly. These people are out in the streets screaming and yelling for what? For what? They live in a state where abortion is permissible. It's not illegal. It doesn't make any sense to me.
All right, let me try to get us back on track.
Okay. I'm sorry. I'm sorry.
All right, so in viewing any alteration in the original structure of government as a degenerative process, the first thing that comes to my mind is, and it's coming, the 17th Amendment.
Oh, yeah.
Electing senators by direct popular vote instead of selecting them through the state's assembly.
Right.
For those of us who don't know what the 17th Amendment did, it enabled us to elect our senators, where prior to that, the state legislatures would assign them and could recall them. to the Senate.
Yes, you're a very positive person, Rob. I wouldn't have said it enabled us to vote directly for the senators. I would have said it disabled the states from selecting them.
And what that did was it kept us from being able to recall them as well,
Obviously,
except through the next election.
absolutely,
cycle.
we'd have to either wait for them to commit a crime, an obvious crime, and get a grand jury involved in it to literally pull them out of office. I mean, there are different ways of doing it. The longest is to wait for the elections.
And now these senators now have millions and millions of dollars coming into their coffers to help them with their reelection from the day they get into office.
Yeah.
None of them leave poor or destitute.
No, that's what the Greeks meant. You turn an aristokratia, an aristocracy, into an oligarchia. It degenerates into an oligarchy, those ruled by the wealthy. The thing I have never seen, with the possible exception of maybe there are a few good-hearted, good people, and who comes to mind with me are the Pauls, Ron and Rand. These are not corrupt people. They're not corrupt. You could tell by their activities. Even Truman said that, anybody who comes into government poor and leaves rich is a crook. All right. But what they did was they turned the aristocracy of the Senate, and Senate comes from the Latin word signore. It means an elder. So these were supposed to be wise elders in an aristocratic position. Okay. And according to the Greek term, aristos, what they're talking about is people who were morally and ethically virtuous. They were honorable people. Well, you've turned that with the stroke of a pen, you've turned that aristocracy into an oligarchy. Now, their intent was in the Constitution to protect the sovereignty of the individual states. That was the purpose, the very, very heart of having a federal government. That is what the Iroquois gave us, the idea of federalism. Federalism had its knees kicked in with the 17th Amendment.
Okay, so altering the structural foundation really annulled the Senate's function.
Oh, absolutely. Absolutely. So once again, you've got structure governing function. The structure was knocked out from under it. The underpinnings were knocked, and the Senate's function is gone. The states are no longer represented in Washington to protect their sovereignty, which is why you return to Roe v. Wade, which is why an opinion by the Supreme Court can have a devastating effect on all 50 of the nations under our federal government. Now, remember, there is a difference between a national government and a federal government, okay? The national governments are found in each and every state. Every state in the Union is a nation, all right? When you pledge allegiance, you say one nation under God. That's not true. It is 50 nations under God, united under one federal government. People seem to forget that. We don't live in a single nation. We live in 50 nations.
Okay, Tom, I should say Dr. Tom.
Now you can call me whatever you want.
Well, Dr. Tom, what's the first order of business then?
Well, like I said, the first order of business would be to protect the idea of federalism, number one. Okay. So the first order of business would be to review any amendment, act, or anything that comes out of government that strays from the original intent as understood by the drafters. All right. And bring it back into line by abolishing that amendment, act, or law, either in toto or in part. At the same time, we should be able to preempt any legislative attempt to alter, abolish, sidestep, or work around any other structural characteristics of the three co-equal branches of government, of that government's framework. The most important of which is the Electoral College for the executive branch. Okay? In any case, here is priority one: to reaffirm, repair, and reinforce the structure of government. We were not intended to have a direct vote democracy. We were intended to have a representative constitutional federal republic.
Well, that makes sense to me. It sounds like a tall order, but how can we be sure what their original intent was? I mean, do we have to go through all the historical documents that preceded the creation of the Constitution and so forth to get to that?
Well, Rob, you're jumping ahead again. Okay. As I said, this would fall under materials and methods within our tactical response. We're not there yet. Okay.
All right. I guess I'm jumpy today. All right. Let's go on. We have our first priority.
Yes. We'll get you where you want to go. Just be patient. There are other dysfunctions we have to identify and prioritize. I think the next priority would still be under the category of original intent, and that's correcting federal overreach found in anti-constitutional and extra-constitutional actions by each of the three branches. I guess we could call this the legislative violations of original intent.
Well, I think this should be easy enough. We could identify these kinds of violations by simply looking at the preamble to the Constitution. Doesn't that, in fact, lay out the general and intended functions of the federal government?
Yeah, well, yes, it does. We already have a clear statement of the purpose of the government within the preamble. This could very well be the standard against which we can make generalized comparisons. However, more specific comparisons are also found within the document itself. As we go along, we will be able to locate precise dates and identify the pathologic agendas behind the assaults on the people's rights. It is most important to clearly reassert the role of our government intended for our societies to keep us free.
All right, so we have our first category of priorities, violations of original intent. And to summarize, this can be further divided into structural and legislative. So, Dr. Tom, where do we go from here?
Let's think about that a moment. All right, structural violations of the original intent are pretty much cut and dry. We know where we were and we know where we are now. All right, examining the destructive effects of these changes is a simple process. The legislative violations of the spirit of the original intent require more concentration. Since we know that we should always look at consequences rather than supposed good intentions of any act, we should determine a standard to identify the most damage to the people's rights and where it has occurred. This would necessarily require a very close inspection of any bureaucracy set up with regulatory and rulemaking authority, which imposes their will upon the citizens without proper legislative processes. We'll take a more aggressive look at these a bit later. These can be measured using two different lenses. The first is damaging effects on society, and the second is found in equity.
I think hindsight is a good teacher when trying to identify the damaging effects of any law. But, whenever I hear that word equity, I have a little hives. Can you clarify what you mean?
Well, first of all, you're right in most cases. But hindsight doesn't really seem to be a good teacher when politicians are involved. By the repeating cycles of their actions, they never seem to learn from their failures and keep repeating the same mistakes. Take the prohibition of alcohol and the Volstead Act as examples. When the denial of the people's natural rights became so unpopular, the outraged societal reaction led them to being repealed. All right? Anyone with half a brain could have predicted how the American people would have responded to this kind of an intrusion into their personal lives. This didn't seem to make anyone in government think twice about passing the war on drugs or any other form of prohibition afterwards. That came afterwards. The question they never asked themselves is, and then what? As far as equity goes, the question that raises goosebumps on your skin.
Not goosebumps, Dr. Tom, hives.
Hives. All right, we're saying, okay, an erythematous reaction. Okay. As far as that goes, we have to set up a simple standard to determine at what point does taxation shift from legitimate fees for the essential operations of government to coercive theft. We would have to determine where, how, and why the people's monies are being stolen and put an end to it. This abuse is so widespread across government agencies and the result of such blatant violations of constitutional restraint that it boggles the mind.
I think you're referring to government bloat. Am I correct?
Yeah, you see, yes, government bloat, operational expenses, the debt that politicians call public debt. Imagine that. It's government debt. And they call it public debt. The bloat you are referring to comes from a lot of causes, all of which were meant to be outside of the government's authority.
All of them?
Every single one of them. These government agencies set bureaucrats into petrified positions within the framework of government. They render any change in political administrations by the will of the people through the ballot box practically impotent. Since they owe their salaries to one political party or the other, you'll never find one that's bipartisan. They claim they exist to facilitate the interactions between the government and the public, but all they do is increase resistance to any enterprise the public wants to take. Think about it. They create a roadblock with rules and regulations and say they are there to help the public overcome that roadblock. You know, it's just ridiculous.
Okay, I'm having trouble seeing that they all are problematic, but I do recognize that they're always at a cost.
Yeah, they're always at a cost. And I can guarantee you that if we sat down and looked closely at every one of them, we would find a reason that they should constitutionally not exist. Okay. They're always at a cost. They're always at a cost that wouldn't have been there if their arbitrary rules and regulations were not there. All right. You just reminded me of something of my buddy Vince Testa told me a while back. And I think it sums up government intrusion pretty perfectly. He told me that when he was a kid, he was with his family crossing the Delaware River on the Walt Whitman. Right? They stopped to pay the toll. And he asked his father why they had to pay a toll to cross the bridge. His father turned to him and said, it was to pay the salary of the guy collecting the toll. So there you go. You know, if the guy wasn't there, you wouldn't be paying the toll to pay the guy who's collecting the toll.
I remember that toll was supposed to be for a limited time until they paid for the bridge, and then it was supposed to be minimal, if anything, just to pay for maintenance. But it's turned into quite a money collecting operation over there.
Oh, it was one thing. One day we will
I crossed that bridge many times.
Oh, so have I. I had to go across it every single day going to school. Rob, one day we have to do a podcast on a tale of three bridges: the Tacony Palmyra, the Ben Franklin, and the Walt Whitman. You're right. The Ben Franklin Bridge was sold to the people, telling them that once the bridge was paid for, that the money would be going to create another bridge further down the Delaware. And that bridge was the Walt Whitman. They said that once the Walt Whitman Bridge was constructed, then the Ben Franklin Bridge would have been free of charge. Anybody could cross it, no problem. But that didn't happen because politicians are liars. It's that simple. You can't depend on these people to tell the truth, and you have to assume that they are corrupt. It's really an unfortunate thing. That's why our government was created, with a diffusion of power and checks and balances. Because for all of the oath swearing and, yeah, I swear this, I'm going to abide by the you can't believe these people. You show me any law that was passed that would be, let's say, rare, safe, and, you remember how they tried to sell Roe v. Wade? You remember it?
Safe, legal, and rare.
Safe, legal, and rare. What happened to the rarity? It was a lie. It was a complete lie.
Well, now we ended up using it as a form of contraception now.
Exactly. So where's the rarity there? It may have been safe. Legal, it shouldn't have even entered into the mind of the federal government, the people in federal government, to even have a say in it.
Okay.
Well, in any case, let's
try to stay on track.
So, yeah. Well, I keep getting sidetracked. I don't know why. I get pissed.
Well,
what can I tell you? I get pissed.
It's in your genes, like mine.
Yeah, Italian and Greek. So I got the best of both.
All right. So let's summarize at this point. We've got a mission statement. Our categories to review are breaches and violations of original intent in structure and by legislation. I think I've got my notes right on that.
Yeah.
Our first order of business would then be to clearly reassert the role of government by reaffirming, repairing, and reinforcing the structure of government. Then, under legislative violations, we have the amendments, which led to the creation of federal agencies with regulatory powers invested in them and laws that had damaging effects on our natural rights, some of them very well-meaning. Added to this, we have to review any amendment or law that results in an economic or commercial damage to our citizens. And this you called equity. I'm still scratching at that word, but you called it equity. Is that about right?
Yes, it all sounds about right to me. Yeah, sure.
All right. This sounds like a very, very tall order. But I have to ask you, how do you think things got this far? I mean, wouldn't you think that a lot of these things could have been stopped by the Supreme Court, or at least by one of the three branches of government as they were occurring? That's why they were set up.
Well, the Supreme Court cannot act on its own, all right? The case has to be brought before it following a legal process. It has no authority to interfere with any legislative act, until it's officially brought before it. So the executive can either refuse to sign or veto a proposed bill into law, but there are legislative mechanisms to overcome these acts as well. It would be a real task, you're right, to evaluate every act that was antithetical to the constitutional intent to see where the fault lay. But I can clearly tell you what methodology was used, and the mental masturbation and legal acrobatics which got these things passed. It really isn't as complicated as it is devious and readily identifiable as it is happening.
So what you're talking about is collusion. That's my new favorite word after the last couple of years. Collusion by three branches of government to allow this all to happen. Am I correct? I mean,
well, I wouldn't know. I wouldn't say collusion. It sounds like a good word, may very well be accurate, but we have to assume that if it wasn't by collusion, it was by sheer ignorance of what was being damaged. There was no foresight there. There was no way to pre-tell. These things get passed with a lot of good intentions. I couldn't give a rat's ass about good intentions. Good intentions mean nothing to me. The effects of what happens is what means everything to me. What are the consequences of what they do? Those good intentions could be 100% sincere, or they could be 100% corrupt. Good intentions. Hey, the road to hell is paved with good intentions. I mean, we have that expression, and it's right. It's a correct, your good intentions for you may be a complete violation of my rights for me.
Okay. Well, you said it really isn't as complicated as it is devious and readily identifiable. This I want to hear. I just can't imagine getting some of this stuff passed through that we are all suffering with today.
Oh, and here's the thing. Knowing their tactics will arm us with our own counter tactics. It provides us with our materials and methods that I was speaking about.
So
right?
I'm sorry, I didn't want to interrupt you.
No, that's okay. Go ahead.
You're talking now about us versus them, tactics versus counter tactics. Sounds a little bit like a war. In fact, it sounds a lot like a war.
It is a war. We are in a war to save our federal republic.
So we're finally getting to where I wanted to go. So why don't you take us further and tell us about these methods and materials?
All right. Well, let's look at their tactics. Okay. There are three factors used by the left, or if you want to call them progressives or Marxists or American Marxists, whatever you want to call them, to bypass original intent. They hate the Constitution. The Constitution is a roadblock for them. They've got to get rid of it. And if they can't get rid of it, they got to work around it. They call it that. They call it a workaround. So we'll call it a workaround, okay? There are workarounds. The first is ignoring a long-standing legal maxim applied to contractual and other legal texts. The second is applying broad interpretations to a text with an obvious narrow intent. The third is changing the definition of words within the text itself to dilute the meaning of the original intent. Rather than just tell you, right, I'm going to set up some premises and walk you through an exercise. All right. With an example. You have your pocket constitution with you?
I sure do. I have it on the desk here because I need it whenever I'm talking to you. I guess this is going to be fun. Go ahead.
Yeah. Well, it was always fun for me when I was a kid. We'll use the same method my father would have used. Okay.
Yes, I remember some of those from your book. So I'm ready. Let's go. I'm up to the challenge.
All right. The first premise is that when a bunch of lawyers get together to write up some legal document, you can bet your life that they will word it so that their meaning is unambiguous. This means that their words are to be understood with the narrowest of interpretations. You've been involved with contracts, as a businessman. Would you agree with that?
Absolutely. I've had to defend against contracts, and I've been a plaintiff and a defendant. So I know them. I know that they are trying to be unambiguous.
Okay. You want clauses to be narrowly interpreted, not broadly interpreted. Okay. You want their meanings to be clear and not subject to interpretation. Okay. I want you to first look at the preamble of the Constitution and read it to me.
Ah, that's my favorite part.
Okay.
All right. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
Okay, that's good. Okay, sounds pretty straightforward, doesn't it? Now I want you to go to Article 1, Section 8, Clause 1, and read it to me. All right, the Congress shall have the power to...
Okay, to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States.
Okay, now stop there. Okay, I don't want you to go into everything enumerated. Now I want you to go to the 10th Amendment and read it to me. Remember, this amendment literally defines federalism for us.
10th Amendment. Okay. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
Okay. Now, I want you to keep these three statements in mind. All right. Now, here is the second premise. In any legal document, when specific things of a similar kind are named, listed, or enumerated, there is a logical exclusion of all things of that same kind which are not named or listed. This is an ancient maxim in law. All right. In Latin, it's designatio unius est exclusio alterius et expressum facit cessare tacitum. In English, it means the designation of one is the exclusion of another, and that expressed makes that which is implied cease.
Tom, I hate when you do Latin on me, but I think I get it.
Hey, it ain't my fault it's Latin. But just looking over these three statements and those two premises, what do you get out of it? What do you understand? Now, neither of us are lawyers, okay? But these are premises. These are logical presumptions. We're following a course of logic, rhetoric, and logic. We don't need a law degree to understand it. It was not intended for lawyers. It was intended for the people. So what do you understand?
Okay, I'll give it a go. Okay, firstly, the framers wrote what they meant, and they meant what they wrote.
Mm-hmm.
Secondly, that what powers were listed or enumerated were the only powers Congress had, and it could not assume any others that weren't listed. In other words, the Constitution was only to be taken in the narrowest of interpretations, and no broad interpretations were to be implied. Do you think I have that right?
You got it right, and you just became a constructionist. That's what constructionism means. Going back to the original construction and understanding the clauses and what they meant, okay? So with the so-called general welfare clause, let's say, Congress has the authority to raise taxes for the general welfare. But it follows that the enumerated powers limit the federal government's spending to specific areas. It wasn't constructed to mean anything they wanted it to mean and interpreted in any way that they wanted. It was only for general national purposes, okay? The clause indirectly disqualifies the appropriation of tax revenues for any specific local or special interest reasons. What does this tell you?
Well, are you implying, first of all, that the federal highway system was inappropriately started and funded by the federal government?
No, not at all. The federal highway system is one of the things that they had the power to tax for. You know, they called it post roads back then. You could easily say, well, hey, this road is necessary for defense. As a matter of fact, that's what they used to determine the width of a lane on highways, was the width of a Sherman tank. Okay, so it was justified in 1959, I believe, by Eisenhower. You know, when we started these projects, it was justified to provide for the defense of the country. But it's also for the post, the post roads, for the mail. So that's justifiable.
I got it.
All right. What isn't justifiable is bailing out a friggin' bank. That's not justifiable. What isn't justifiable is buying the shares of General Motors. That's not justifiable. Do you see what I'm saying?
Yeah, I think what you're telling me is there's a lot of work to be done to untangle the misappropriation of our tax monies.
Exactly. You got that right. Then there's still another problem to tackle, though. We've got to get back, and that's grammar. Let me ask you, do you think the meaning the framers understood for the words provide, promote, and welfare are the same as we take them to mean today?
Dr. Tom, I hate when you do this to me. That sounds like it's a leading question, but I'm going to answer it. I'm going to answer no, but I wouldn't be able to tell you why.
Well, if you answered no, you'd be right, especially with the word welfare. I'll give you a hint. The meaning we use today first appears in our dictionaries around 1904 and was further morphed in about 1918. Placing the words welfare and state together is only with us from 1941. Let's just make a clear point when talking about construction in legal documents. Words have precise meanings, both in the legal and general usage. Link them together into sentences, and they express exact ideas. Let's say we sign a contract, and afterwards, I gradually change the definition of one or more critical words, like we talked about previously. Is the contract still valid? Have the terms changed to the point that it is no longer the contract we both agreed upon? What effects do 21st century definitions have on documents written in the 18th century? Can you see where I'm going with this?
I certainly think so. I mean, well, I already read your book and saw what happened to the word unalienable. We pronounce it unalienable.
Right.
That's the way it was pronounced, unalienable. So if we truly want to understand original intent, we can rely solely upon the words in the text. We don't have to second guess what each of the drafters were thinking. Their words say it all. I would also take this to mean that we can call upon the historical context in which the document was written, as well as the grammatical and linguistic state during the time it was written.
You've got it. You've got it. And this also gives us the tools we need to back our understanding of original intent. You asked me before, how do we get to original intent? Look, it's not our role to try and think and get into the minds of what their mental processes were when they came up with these documents, when they came up with these clauses. We know by what they said what they meant. Now, I mean, it would be nice to go, to Federalist 45 or Federalist 83 and read them and say, well, hey, listen, Madison said this and Jefferson said that. And that's all very nice and well. But we don't need to do that because we take them at their word that what they said, they meant, and what they meant, they said. Period. It's a legal document. Okay. All right. So this now gives us our materials and methods to determine original intent. The materials are, first, the original document as written up to the 10th Amendment. Okay? We can all agree on that. We're dealing with the Constitution. Second, Black's Law Dictionary. Hopefully, in addition, as close as possible to the founding, because Black's actually started in the middle to later part of the 1800s. So it was a distance. But, any other British or American law dictionaries from the time will also do. I mean, because the reason I say British is because these were British people that were writing these American documents. Okay, let's state it the way it is. Third is the Oxford English Dictionary. That's another one of our assets. And fourth would be any good etymology reference.
Why specifically the Oxford Dictionary?
Because it is an historical dictionary of the English language. It includes not only the many different meanings of words, but it also gives examples of how each word was originally used and how its meaning has changed through time. It also gives you dates of when it changed, when the word changed. You can easily date the meaning of the word to a specific time frame. So, if you go to the Oxford English Dictionary and you look up the word unalienable, they'll tell you that unalienable, comes from approximately 1510, and it means precisely what I said it meant. Okay? Then it will tell you the changes.
Okay, Dr. Tom. Now, progressives have been at the destruction of the Constitution and America in general for over 100 years. I guess I'm saying to myself, how do we put the plan into action without waiting 30, 50, 100 years? These folks aren't going to take this lying down. We're talking about us versus them again. For instance, we can't repeal the 17th Amendment. The existing senators they'd never vote for that. As far as the other ideas, we have the federal bureaucracy opposed to changes at every turn. Remember what they did to Donald Trump.
Yeah.
Then we have, I don't know how many people, is it 25, 30% of people who work for the federal government? They stand to lose their occupations with some of the things that we're going to be doing. These folks have jobs, they pay taxes. I've worked with them in my prior businesses. They seem patriotic for the most part. So we have to find a way around all of this.
Right. Yeah, well, you're right. Number one, we can't depend on the people within the government to change, to revert back to the original structure of the government. We can't depend upon that. So, but there is a mechanism to deal with that. As far as the bureaucrats, yes, they would resist everything, as well as the people working in government. But to tell you the truth, you made a statement that they pay taxes and things like that, and they don't pay taxes, Robert. Nobody who works for a government enterprise pays taxes. You've got that wrong.
It certainly seems like they do. They file federal income tax papers.
Yeah, what does that mean? You pay their taxes as a citizen. Your taxes pay for their salary and their taxes. You don't seem that it doesn't matter how you cut up the money that they receive. It's all coming from you. So, they are not producing anything of their own labors. They are being paid by taxes. You're a businessman, Robert. You're a businessman. You hire a person. Do you sit there and think about the base pay that the person is going to receive in your payroll, or the salary plus their taxes, plus their insurance? You think of the total aggregate, don't you?
I'm very familiar with that, yes.
All right. So to say that a person who works in government pays taxes is ludicrous. He's paid from taxes. And any percentage that he further passes on to the government, that means nothing. It means nothing. He's not paying the taxes, you are. Now, you add something to that. Add to it. There used to be a time that people worked in government at less pay for the security of working in government.
That's no longer the case.
Well, no, it's not any longer the case, because they earn approximately 25% more doing the same job in government that you would be doing in the private sector. So where is the benefit to the taxpayer to have these people there? And you ask me, well, what's going to happen with these people? Don't you feel bad? Maybe they're going to lose their jobs. No, I don't feel bad at all. Not at all. What do I care? Why should I care? Let me ask you something. Do they care when they shut down an industry? Do they care when auto workers are laid off because of rules and regulations written by the EPA or this or that or whatever? Do they care when they shut down a mine? Do they care when they shut down, I don't know, when they impede farmers? Do they care? These are the people that they work for. These are public servants, and they have absolutely no compunction of writing a rule or a regulation that'll throw a couple 100,000 people out of work. They don't care.
Well, Dr. Tom, in a previous business, I dealt with a lot of government employees. These were rank and file people, and they seemed like very good folks. They didn't have an agenda. They were just trying to do their jobs.
Well, the question you have to ask is, how essential are they to the operations of government? Okay. I mean, if you really want to see how many government employees are essential to the operation of government, just wait for the first snow day. That'll tell you everything you need to know. I used to hear it on the radio. All non-essential government employees, please remain home. And 90% of them stayed home. So what that's telling you is that we have only 10% of the people that are employed are essential to the operations of government.
But if 50 million people lose their jobs all at once, that's a significant impact.
Well, that wouldn't happen. We're talking about the federal government. And not only that, it's not all people in government that would lose it. Military people wouldn't lose it. We're talking about organizations that are set up that are actually causing damage to the population. So not only are they causing damage to the population, they're also a drain on tax monies. I have no sympathy for people working in government.
You're talking about the FTC, the EPA,
and that's
Centers for Disease Control, those kind of agencies.
Yeah, exactly. Health, education, and welfare. Department of Education. What do these people have? Why are they there? They're just there to cause trouble. That's all. There are essential operations of government, but the majority of government employees are not involved in those things. They're in things that were created anti-constitutionally. So they've been deriving an income, off of the backs of the American citizen. All you have to do is think about this in one moment. From the time of the creation of our government, all the way up until 1913, government at all levels of operations, or local, county, state, and federal, operated at 3.5% of the national income. Now that's from 1789 all the way to 1913, with the 4-year exception of the American Civil War. It went up to 5% then. So you have to ask yourself, why is it that the operations of the government today is 47% of the national income? It tells you everything you want to know. All you have to do is follow a graph, and it'll tell you where the largesse is.
There are some who would say that were we a more virtuous society, we would need necessarily less government. But because we've become, I don't know the right word, needy or non-virtuous, what's the word I'm looking for? Decrepit? I'm thinking about one of my uncles now. We wouldn't need so much government, but because society's gotten a little bit sicker, government has come in to fill in and take over the role of arbitrator.
Well, my point of view in that is that you're looking at it incorrectly. We've lost virtue in society specifically because of the government intruding into our lives. Basically, the loss of virtue in society is a reflection of what's going on in government, not vice versa.
I think you make a good case there. I remember Thomas Sowell telling us that prior to the civil rights movement, Black American family households had a 75% intact father and mother.
Oh yes, that's true.
Family
that's true.
relationship, and now After all of the social welfare programs and so forth, we've reduced that to less than 25% of African American households
Exactly.
are intact families with a father and a mother.
Exactly. If I'm not mistaken, I don't know the numbers, but I think remember hearing Dr. Soul talk about this as far as black employment. For example, during the Depression, black employment was higher than white employment. You know, they had a family structure. They were religious people. They had a two-parent family. They were respectful of the law. They were respectful of their religions. You know, that all changed when you made an incentive to throw the father out of the family. It all changed. So
your point is well taken then.
Well, I would think so.
Well, here's what I would say. The progressive, well, really the Marxist movement, according to Mark Levin in his book, The American Marxism, that's taken over 100 years. And I'm watching the country degenerate, and I don't think we can wait as long as they have. What would be left if we did? So let's end this with something positive for our folks, and then we can go on to the next podcast and talk about some of this other stuff.
Okay. All right. Well, yes. Mark Levin also came up with the solution. We can't expect these people to change themselves. We can't expect people who have grabbed power to release that power. Now, remember, it's not the government. It's the people in government, okay? And it would seem to me that Mark Levin's solution is the only viable solution that we have, and that's a convention of the states. It's a constitutional convention of the states. We have to bypass these people, but we have to go in there with our books in order. Now, there are people that say, well, that's dangerous. We can't. Is it any more dangerous than allowing a bunch of thieves in government to write amendments? I mean, you know, these people who would object to modulating the power of the federal government and bringing it back to what it was originally intended to be are enemies. They are enemies to the federal construct. And why would we even listen to what they have to say? You know, I mean, it is the same process, you know, in Congress as it would be at a convention of the states. And that's exactly what we have to do.
All right. Well, so in the next podcast, we'll be talking about the convention of the states, how that happens, how it starts, what happens during it. It's not quite as complicated as many people think. There's ways for many of us to be involved too. And we'll go into that. So with that, I would thank you, Dr. Tom. It's been a great interview, and we'll look forward to seeing you next time.
All right. Thank you, Rob. Thank you.
You've been listening to the Liberty Brief, based on the book Unalienable, What It Really Means and Why It Matters by Dr. Thomas Giordano. If you want to help spread the word, please subscribe, like, and share using the links below. You can also check out Dr. Giordano's book on Amazon using the links as well.